Honorable Mr. Justice S.J. Mukhopadhyay, Chairperson NCLAT, Dr. S.P. Narang, past Secretary of Institute of Company Secretaries, Mr. Nisar Ahmed, the past President of Institute of Company Secretaries, Mr. G.P. Madan, past Chairman NIRC, ICSI, Mr. Yogesh Gupta, past Chairman NIRC, ICSI, other senior members, friends, good afternoon. At the outset, I, on the behalf of ICSI IIP, thank Your Lordship for sparing Your Lordship's valuable time, that too on a working day. And that's how when my Lord came and we were sitting here just for a cup of coffee, my Lord asked me, people are there? Log aaye hain? I said, I'm not sure, my Lord, how many people will come. It's a working day. And trust me, when I reached, it was almost half. So I was not very happy. I said, yaar, half hall, acha nahi lagta hai. And by the time we entered the hall, it's full. So I said, my Lord, it's only because of your name. We organize program, but people always come to listen to you, my Lord, because of the charismatic way of speaking which you have. And that's how Nisar sir was also mentioning. In fact, Lakshmi madam was mentioning. And in fact, the credit for this program goes to our member C.S. Lakshmi ji, who is in a way handling the IAP affairs, and this program was in fact conceptualized by her. Unfortunately, we got a regret from Justice M.M. Kumar because he is not keeping well. Yesterday also he couldn't hold the bench, and today also my Lord couldn't hold the bench. In fact, I was also unwell 3-4 days, and that's how I called up Lakshmi ma'am yesterday that I am not sure whether I'll be able to come or not, but I'll take rest, and I would certainly like to come and learn from Your Lordship, because whenever I hear Honorable Justice Mukhopadhyay, it's always a learning. You know, the topic itself is very interesting, interactive meet on IBC. And I remember when we have earlier interacted with my Lord on this topic and requested my Lord to speak. This topic itself has become so interesting that we don't need to prepare any questionnaires, although we have made some questionnaires. IBC, I feel it is actually not only insolvency and bankruptcy court, it has become industrial blood cells. So that's how I call IBC, and these blood cells have actually gone into my Lord. You know, this is what we say generally in our office, that IBC has gone in blood of Honorable Justice Mukhopadhyay. Like, he talks of IBC every moment, and my Lord can create a new proposition out of the already settled proposition by my Lord only. So that's the way my Lord interprets the provisions. I have had the opportunity to interact with my Lord on many occasions in earlier programs also, and that's how we learn. And that's how we learn so many new propositions, just by interacting, just by listening to my Lord. And that's how I would say you all are lucky, we all are lucky that my Lord agreed. So to begin, would request our past President, Mr. Nisar Ahmed, to please present a flower bouquet, and request you all to give a big round of applause for Honorable Justice S.J. Mukhopadhyay for sparing his valuable time and coming on a working day after court hours. Thank you, my Lord, for always blessing us, always encouraging us to hold more programs and share the knowledge with our members. Before I request Honorable Justice S.J. Mukhopadhyay, I would request Nisar ji to please, if you wish to. Okay. We all are eager to hear to Honorable Justice S.J. Mukhopadhyay, so would request Justice Mukhopadhyay to please come over. Before we have the interactive meet, would request my Lord, if my Lord is comfortable from there, my Lord may address from there as well, or otherwise, whatever suits.
Good afternoon to all of you, my brothers and sisters, the professionals. The best part, I feel honored when I stand up before you. Because all the time the lawyers will stand up and you will stand up, I will be sitting. It's actually I am gaining my weight, so I may lose if I stand before you. Now I do not know the address, because address I used to hit since my young days, because at about 4:20 is the time. I think if you look into the timing, it's a 4:20. And people are in a mood to take some rest after the lunch, etc., going to the home. It will be very boring if I give an address on that. The thing is that now approximately 3 years going to pass after this IBC has come into force. He has given one meaning. I say IBC is more like IBS. IBS means irritable bowel syndrome. If you read it, you will have to go 10 times there. So the bowel syndrome will be there. And that syndrome started with the professionals who tried to train themselves. Nowadays, the training is going on for the purpose of the insolvency professionals training and a course, graduation course. Instead of the 10 years, now they will be trained within 2 years and they will be coming straight away to the line. But you have trained yourself. You have trained yourself. You have opened your office. And you have now a number of persons who are working under you. That is the best part of it. I was at Bhopal and I was told that the best of the professional, he has filed the return of 132 crores. 132 crores is the annual return of the professional from the profession. Now they have opened the office. There are problems which are being faced by the professionals. The problem is, first of all, that how every day the change is going on and new things are coming up. One, by way of our judgment. Second, the dimension of the insolvency cases are changing. Third, the amendments which are being made. And lastly, the hand twisting by your persons who are engaging you. Many of them who are engaged by the financial institutions, and let me be very frank, you want to retain the clientele. The bank is your client. You want to retain that client to keep him in humor, so that in future he will again appoint you as a professional. But when the work will start, they may twist your hand and may ask you to act in one or other manner. This is also being reflected in many places. People sometimes blame the resolution professionals. Sometimes adjudicating authorities are passing order adverse to the resolution professionals. Sometimes matters are referred for the purpose of departmental proceeding, disciplinary proceeding. So various problems are there. In one side is these things, the other side is to perform the job with regard to different nature of companies. Somebody says, how we can function in a company if the company is a sell company? If the company is not a going concern for last 5 years, 7 years or 10 years, and the tribunal or the appellate tribunal says, you keep it as a going concern, how that can be done? So all those problems are there, but before deciding that, discussing the problem, we should also note that what is our duty, where we are failing or where we'll have to improve. May not be failing, but we'll have to improve. Particularly in collating the claim, how we collate a claim. And then there are various things which are dependent on that. Thereafter we'll be going to section 30 when we'll be looking into the question of resolution plan. preparation of the information memorandum, what is the timeline to accept a resolution plan, different dates, and other problems are also there. When we go farther ahead, and many questions were there, particularly when I was invited, I was asked that you address on the question of section 66. I said, I'll be talking about section 43, 45, 66, everything. But before that, there are other provisions which we'll be looking into, and discussion will be in a manner. I'll be putting also the question to you when you will put me simultaneously question for the purpose of answering. Now the new amendment has come. The amendment talks of amendment of the section 30, subsection 2, subsection B. Amendment also talks of the subsection 4 of section 30, the duty of the committee of creditors, how they will be looking into the plan. But this committee of creditors, when they will be holding a meeting, you are the person who will be chairing it. It is a resolution professional who chairs it, who plays it, and how they discuss and what you will have to do. And are we doing or playing the same role? That means in various places, if you have seen, some of you have maybe there, where I have stated that adjudicating authority is like a Vishnu and creating the Brahma, that is the resolution professional. And resolution professional in their turn are creating the committee of creators like Brahma creates the human being who will play and do the things. But do you feel that you are like the Brahma who has created the committee of creators, or you feel below the committee of creators? That mental level of a matching, that I am under the committee of creators or committee of creators are under me. To what extent I am responsible to the committee of creators, to what extent committee of creators are responsible to me, or they don't have jurisdiction and I have the jurisdiction. So these are the things where I think a new outlook is to be given, because we have crossed about 3 years. And in 3 years, now we have experience, practical experience of the field and what is going on. So I will not be giving a lecture on the basis of the provisions of the law at this stage, which will be like a teaching a student, which I dislike because you are more experienced professionals than me. I am theoretical, you are practical. You have the experience, I don't have the experience. I have the knowledge from you. But the exchange of knowledge, your knowledge from the experience, my knowledge from the reading of the book. So both if matched together, then we can understand the law in the best manner, how the things can move forward in the interest of judiciary, where I am a part in one side and you are the part of the other side of the coin, and both the part of the coin has a value in the market. If one side has a stamp and the other side has no stamp, then coin will never ring. Thank you very much for calling me here to give some answer. And what I say to everybody, ask the questions. Like an arrow as used to be given to the Bhishma Pitama, who will fall down and may reply or may not in a position to reply. Thank you very much.
Thanks, my lord. Much obliged for your initial address itself. I know you generally, my lord always refuses to give any address. My lord always says that ask me questions, and all these replies, which later on a disclaimer will come, I am sure. But I am giving this in the beginning itself because of my previous experience of moderating my lord's session and also getting this done for my lord. that all this, whatever we will be discussing and the views which will be expressed by my lord here, would be academic only, and it cannot be, it cannot be referred to as my lord's view anywhere later on. And that's how I thought I should start with this disclaimer. My lord, we have already received some questions, so I'll begin with these questions and then we'll have the floor open for members to ask the questions here. My lord, the first question which we received is that whether 330 days are enough for achieving the intent of the and the objective for the course.
180 days is enough. 180 days is the date prescribed, not 330 days. 330 days includes our period. Don't take share of our period. Limit yourself within your period. Am I clear? Your period is 180 days. Rest are discretion of the adjudicating authority to extend and not to extend. Not your period. 180 days you have a right. More than 180 days you don't have a right. So, substantive portion is there. That is, 330 days is in addition of the timing of the court. If you can't do it in 6 months, how do you think that 3 body, adjudicating authority 1, appellate tribunal 2, and the Honorable Supreme Court 3, they will do in 10 days. Will you give us 10 days? For issuance of a notice, 15 days time? For receipt of reply, then file will give me time. You are filing petition for us. We issue notice. It comes. My lord, my lawyer is not there. Give me another day. How will we move? Can we do justice? Therefore, don't say 330 days, 180 days. Complete, you can. Now, you had the problem because of inexperience. Now, all of you are experienced people. 30 days for collating claim. Then, constitution of the Committee of Creditors, information memorandum, and the regulation says 75 days. 75 days means 2.5 months. Enough. If 75 days goes, 105 days, a committee of creditors can't take a decision on the resolution plan. 105 days means how many days? Approximately 3.5 months. And 3.5 months, if a committee of creditors can't take a decision, then when they will be taking decision? So, initial hiccups were there. When we were learning, we used to take more time. Now, we have learned. We have to do it fast. If, according to me, there should be some award, some excess money which should be given if a resolution professional completes within 80 days, 90 days. As early as you complete, there should be a bonus. That will be my recommendation, if I think. And as a lawyer, which I have seen, that a number of persons used to wait in the queue that what is happening in a case. So if I get a case disposed of earlier, more client will come. If I take much more time, then they will not come. So if you get a case resolved within early date, you will be in a position to engage in another one. So more number of cases. If you are in one case and think that it is my employment for 6 months or 9 months, then number of cases will be less. So look from your interest also. Early disposal will be answered. Anything more?
Yes, can you remind this question, sir? Sir, 180 days plus your period, 330 days. Is
No,
it
no,
add up?
no.
Can there be cap on the judicial authorities? Should there be cap?
That Honorable Supreme Court will answer. I cut a joke in my court that let the adjudicating authority takes 30 days, then no appeal for us will lie. Now am I clear? If they take 330 days, where is the question of appeal? So we will be provided with less number of appeals. Let them take 330 days. Then our job will be over, there will be no appeal. At least insolvency case will not be there, we will look into Competition Act and the company law. Am I clear? Yes.
In this, another question which comes out in 330 days, although we all are clear with what my Lord has explained to us in regard to the intent of 330 days. Now in 330 days, in a way, after 180 days.
No, let me cut it off. 9 months means how many days? What is the delivery period of a child? If you can't deliver, then it's not good.
Absolutely. Because in this now, if we read the language of the code also, the amended proviso which has been added, it says provided further that the CIRP shall mandatorily be completed within a period of 330 days from the insolvency commencement date. So one reading was that CIRP shall be concluded, including, I'm reading further, including any extension of the period of CIRP granted and the time taken in legal proceedings in relation to such resolution process of the corporate debt.
Is the substantive provision of section 12 has been deleted?
No.
So substantive provision remains. It is a proviso. Proviso cannot override the substantive provision. Proviso says, the main substantive provision of section 12 says 180 days. That remains constant. It says extend for another period of 90 days. Now, there was no way out of extension, so we used to go for exclusion. That is a new method we started. I think it was with the appellate tribunal started this method of exclusion. So therefore, Parliament was thought that all right, exclusion, etc., everything 330 days.
So practically, 60 days are there for the courts.
No. 180 days and rest is the judicial time.
So that means 150 days.
180 days you complete. Thereafter approval should be there. Process by 180 days by filing it before the adjudicating authority. Now adjudicating authority had no period. Appellate tribunal had no period. Honorable Supreme Court had no period. So now they say after 180 days, the rest period, let the adjudicating authority decide. So what will happen? That adjudicating authority will not grant you extension. Am I clear? Or they may say not 90 days, 10 days, 5 days. Discretion, you don't have a right.
Stay period will be excluded. Stay granted.
Nowadays we are not staying. The adjudicating authority will not stay, nor we will stay.
The Honorable Supreme Court granted stay in home buyers matter for 1 month.
Honorable Supreme Court, we can't comment. They will look into the law. They have a right to say that law is bad. We don't have a right to say law is bad. We are bound by law. They are above, in a sense, that they can set aside the law.
The exclusion which has been given.
Shall I assume that the 30 days shall be excluded from this CIRP period for stay which was granted in home buyers matter?
I can't give answer in advance because I am not an astrologer. What Supreme Court will do, only astrologer can say, not me.
One more question on that. Your Lordship in
Let us be very confined. What I should do, what adjudicating authority should do, what Supreme Court should do is not our question. Question is let us see what is my time. Don't bother what is our time. We will bother. We will try to dispose of within 5 days, 7 days, 10 days. That's our headache. Our headache is not your headache. Your headache is 180 days. Confine to that.
And that too, I believe, if you appear before Honorable Lordship, you will realize my lords have already explained us many times the importance of capsule arguments. And my lord has earlier explained, my lord, if you can explain again.
I'm telling you. I give example of football play. Football play is of 90 minutes. But if somebody plays foul, the referee will blow the whistle. And when it will be taken care of the injured, thereafter it will start. So there may be 4 minutes, 5 minutes extension, so that extra time is granted. So suppose it is 95 minutes, football play is not said of 95 minutes. 95 minus 5 exclusion is the 90 minutes play. Why 90 minutes become 95, can you tell me? Because of the foul. You who are playing, players are resolution professional and the committee of creditors. And other creditors are the football. You are kicking from this side to, if you play foul, then only they come before us. If you don't play foul, there is no extension or exclusion. Why court will stay? You have played foul or committee of creditors have played foul. I am giving one example. SR Steel has changed the complexion and the parliament argued there is an interpretative problem because we have given the interpretation. So they said interpretative problem. They have not said judgment is bad. They can't say. Judgment is good or bad, they could have waited for that, but they haven't did because they thought interpretation may be correct. So interpretative problem is there. What was the fact I am just telling you about that case, which is the eye-opener for the resolution profession? The total debt was collected as 54,000 crore, 54,000 something. 49,100 crore was the collection of the claim of the financial creditors market. 5,000 and odd was the claim of the operational creditors collected. So this total was 54,000 crore. Now, when it was brought to the notice of the adjudicating authority, 7 big houses were there. Urja Vikas Nigam, that's the electricity generating company. Then Hindustan Oil, Petroleum, then Indian Oil, then GAIL. Now their claim was much more than the financial creditors' claim. One had 3,000 crore claim, another had 850 crore claim, a third had something like 750 crore claim. Total 13,000 and odd claims were ignored. The resolution professional said, gas is flowing through the pipelines, therefore it cannot be assessed. Therefore 3,000 crore, I say, let it be treated as 1 rupee. 3,000 crore, 1 rupee. 850 crore, 1 rupee. 560 crore, 1 rupee. 13,000 crore given a mobile. Sorry. 13,000 crore. And when we added to it 5,000 plus 13,000 crore, it was approximately 19,000 crore. and 19,000 crore and 49,000 crore would have been something about 71,000 crore. He had shown 54,000 crore and received 42,000 crore. Is it not a foul play? Is it foul play by the resolution play professionals? And that resulted in appeal. All these people filed application under subsection 5 of section 60, and resolution professionals said, all right. Then adjudicating authority said, give them the totality. Now you calculate about the financial feature with interest, and in some cases you calculate the principal and say, no, I'll not give you interest. Why? Who had the twisting of hand? Somebody must have twisted the hand of the resolution professional. Make it 0. So this twisting of hand may have resulted into this foul play by resolution professional. And then the foul play by the committee of creditors, who said they will get 0% and we get 99.19%. If you go for this type of foul play, because the biggest amount was involved, will be insolvency, then where is the question of 180 days, 330 days? Those questions will not arise. Am I clear to you? So, please understand our business. What is my duty? If we do not play foul and do not allow the committee of creditors to play foul. Now I am giving another issue. SR I am giving. What is 30 subsection 2? Have you read it? Let me read the subsection 2. Section 30 should be read by all resolution professionals in an honest manner. I'll be using the word honest manner. The section 30 says, submission of resolution plan. The resolution applicant will submit a resolution plan along with affidavit stating that he is eligible under section 29A to the resolution professional prepared on the basis of information memorandum. So where they will submit? Before me. I am the resolution professional. Subsection 2. Resolution professional shall examine each resolution plan received by him to confirm that each resolution plan, I am reading the old one first, provides for payment of insolvency cost. B. Provides for payment of debt of operational features in such a manner as may be specified by code. It should not be less than so and so. So who will provide that what amount will be paid to the operational creditors? Who will provide? No. Resolution applicant will provide. And I will scrutinize. So in SR, they could have said that I will be paying 10,000 crore to the operational creditor and 30,000 crore or 32,000 crore to this. Now come to Regulation 38. Regulation 38, subsection 1, capital A. Have you got it in your presence? Look into Regulation 38 and subsection, the sub-regulation is one E. 1A says, because as prescribed by the board, now what board prescribes? The resolution plan shall include a statement as to how it has dealt with the interest of all stakeholders. Resolution plan should say, including financial creditors and operational creditors of the corporate debtor. It do not say secured, unsecured, etc. So they must say in the resolution plan how much we are giving to the operational creditor and how much we are giving to the financial creditors. Am I clear to you? So if they have not shown that how much we are giving, then it is not in accordance with section 30 subsection 2. Sorry, I cannot show. So it will not be in accordance with subsection 2 of section 30 if they do not give. So who will therefore in our judgment will say, as a resolution applicant who will have to distribute that how much I will be giving here and there. Now look into subsection 3 of section.
Sorry for interruption. My
Yes, just let me complete. Now look into subsection 3 of section 230. The resolution professional shall present to the committee of creditors for its approval such a resolution plan which confirm the conditions referred to subsection 2. Suppose the resolution plan do not say that how much I am giving to a operational creditors and a financial creditors. Can it be placed before the committee of creditors? No. Therefore, you may have 10 plans, and if 4 are in accordance with subsection 2, then 4 will go, 6 will not go. In SR still, nothing was given, and it was placed before the committee of creditors, and committee of creditors played the role. Am I clear? So it was a failure on the part of the resolution professional who should not have placed before the committee of creditors. Effect is, committee of creditors have decided how much who will be given. Am I clear? So resolution plan is to say that how much I should give to X, how much I should give to Y. And if do not say, I cannot place it. And if I can't place it, how they will decide? So this created, and then we said that committees of creditors cannot distribute because distribution is to be by them. Judgment is right or wrong, the Honorable Supreme Court said, but section 30 is clear. Now your question.
My lord, there is amendment in subsection 2.
Amendment will be, amendment will be coming. Amendment has not taken away the right of resolution applicant.
Correct.
Resolution applicant is to again say what is to be given. 38(1)(a) has not been amended. If you look into B, the B there is a provision added. Or amendment made. Now come to amendment. Read it with me, the amendment. Again, same thing. The answer will not be different. Subsection 2B provides, the following shall be subject, provides for payment of debt to operator. That means resolution plan provides for payment of debts of operational creditors in such a manner as may be specified by the board. That is 38(1)(a) shall not be less than XYZ. But things remain that resolution plan should provide. Am I clear?
Correct.
Resolution plan should provide what should be given to a committee of creditors. Not less than. It's something more than. Am I clear? Now I am reading another way. Look into subsection 4 of the original one. Original one is the question of the committee of creditors role. Alright? Now, committee of creditors role, if you look into from subsequent, the committee of creditors may approve a resolution plan by vote not less than 70%. The voting of the financial creditors after considering the feasibility and viability of such other equipment as may be specified by the board. Then it talks of 29C. Now, this plan, if you are clear, that means it has said X 10,000 crore, 32,000 crore. Then the question of voting will come. Now, I am reading in my own manner the amendment provision. You know how much harm the secured creditor has caused to themselves. Now I am reading the subsection 4. Now subsection 4 amended. In subsection 4, after the word feasibility and viability, the word bracket and figure, the manner of distribution proposed. Who has proposed? Which may take into account the order of priority among the creditors as laid down in subsection 1 of section 53. So priority of creditors in subsection 1 of section 53(1). Now let us see priority of the creditors in subsection 1 of section 53. Now this is very important. Now I do not know what will be the answer, but I am reading 53(1). The 53(1) talks of distribution of assets. The notwithstanding anything to the contrary contained in any law enacted by the Parliament, which includes the present law. That means section 30, etc. Any state legislature can proceed from the sale of the liquidation assets will be distributed in the following order of priority. So priority will be number P will be after along with the workman is the secured creditor. Do not talk of financial creditor. Let us be very clear. It do not talk of next is the financial debt owed to unsecured creditors. So financial debt can be secured, financial debt can be unsecured, and operational debt can be also secured. For example, this ONGC and electricity company, etc., they have also secured by an agreement. So they can be also secured creditor. So secured creditor does not mean financial creditor. An unsecured creditor does not mean operational creditor. And these 53 do not talk of financial creditors or operational creditors. That word is not there. Now I am giving one just example. What is this 53? Is 53 of a secured creditor? Secured creditor has a right on the asset. Am I clear to you? Now right on the asset is the liquidation value. Am I clear to you? The asset value is 1,000 crore. So secured creditors will have a right on 1,000 crore. Am I clear? They don't have a right more than that. They are secured only against 1,000 crore. Against rest of the amount, they are not secured. So, if the plan says that I am giving 5,000 crore, as per 53(1), how much you can give to a secured creditor? Maximum. And 4,000 crore will go to whom? Next, waterfall system priority. So those who are the unsecured, they will get 100%. Then it will go to third. Am I clear? If I read it like that, because priority in the manner as prescribed in 53(1), now priority means first give to him, if remains, go to the next, if remains, go to the next. Now he has a right of a secured creditor, it is 1,000 crore, all secured creditors. They can't say, I am entitled for 5,000 crore. So, has it cut down the throat of the secured creditors? They are thinking that total will come to us 100%. It may be in a case that 100% they may be entitled to. If 5,000 crore is all secured, liquidation value. But I don't think any resolution plan is accepted on the basis of the mere liquidation value. This is the liquidation value, and I give you liquidation value. It will be always above the liquidation value. Am I clear? Normally it is all above the liquidation value. It may be twice the liquidation value, maybe 5 times the liquidation value. So, how to read the law? But it is not your headache. It is not your headache, they will decide. But if you allow them to decide, don't give a plan which is not in accordance with law, don't give it to them. So what I said, that you are above them. It is case distribution, as they give you, then I am giving this case to you, and similarly you will be teaching them, I am giving this plan to you, not the other plans. Am I clear? Don't give all the plans. If you give the plans, all the plans, it creates the problem, and the foul is played, and then appeal. Am I clear to you?
So many things have, in this one question itself.
One section 30 is enough to understand what is my right above them. Resolution applicant can't go before them till they call for negotiation. They can't say, like we are hearing JP, that another person, so-and-so has also said that we will be filing. How they have gone to you? We asked this question in JP. They said Adani is also ready. Adani is ready. How they can contact committee of cases? Because the resolution plan will be filed before the resolution professional. Resolution professional can say, yes, come, ask me time. Not the committee of cases. Know yourself. You are more powerful. Exercise your power. Then the committee of cases will understand who are you and respect you. Am I clear to you? For example, I show my whole power as a chairperson in the appellate tribunal. Therefore, it has gone up. If you don't show your muscle as a resolution professional, it will never go up.
So many questions comes up from this, although not what you said exactly is also forming part of the explanation which is given in 30 now, that for removal of doubts it is hereby clarified that a distribution in accordance with the provisions of this clause shall be fair and equitable to such creditors. Although I feel if there is a word missing, it should be, shall be deemed to be fair.
You see, hurry, justice in a hurry is just very. What has been done to the, the secured creditors? They have been limited. And unsecured creditors are limited. If you look from that angle, the engineering I have ready, subject to the interpretation which court will decide, including the appellate tribunal. I am just reading the question. I don't know what will be the decision.
No, that's a very, that probably nobody has interpreted that subsection 4 in that manner in which the Lord has interpreted it.
I am reading 53.
53.
That is the reason that is the reason in the judgment we said 53 will not be applicable yet. Now, a joke is there. I cut the joke in various places. 53 is after the death. Nothing remains to sell it. So after the death. Resolution is before the death. So I said, look into two types of bhoj, dinner or lunch. One is after the death, shraddha. During the shraddha, the lunch is given. So secured creditors are Brahmin. Pehle Brahma Bhoj. First, they will eat, the Brahmins will eat. If anything remains, the rest of the persons will eat. This is what is going on in our eastern region and some other region. So they are secured creditors. You will eat first. If anything remains, then the others will eat. And what is the resolution? This is like adoption of a son. Somebody is adopting the son. So it's a happiness. Therefore, you will give the lunch or dinner everybody in the queue to the extent of their stomach. And what is equal treatment? Equal treatment is you eat half of your stomach. So a small person like older person like me, his stomach will be less. A young person like you, your stomach will be more. Financial creditors will automatically get more, and the operational creditors will automatically get less. So this is a joke wise I am saying what is the same treatment and where 53 applies and what 53 do not apply. But now they have said कि जो ब्राह्मण भोजन है अभी भी करा सकते हैं. Alright.
मान लो कि तत्व गई है.
Now if they would have given, at the time of death.
Lord, one thing which fell from my knowledge is that the IP and the IRP or the RP, their role is very critical, particularly with regard to their appointment, removal, remuneration. If everything is to be governed by COC, then why can't a provision be introduced that they are made independent and it should be left to the adjudicating authority to decide upon their appointment, removal, may be from the panel of IBBR?
Various cases have come before us. Every case cannot be decided in one panel. They have a right to remove. Why do you remove? There are two reasons for removing. One, that you are not acting in accordance with our direction. Second, you are taking much more time and not doing the work. Third, there are educational issues. The question was raised that there is no reason given for my removal. We asked a question in the court. If they give a reason, will you be happy? If they say that you are a thief, you have taken right job so and so, will you be happy? If they say you are worthless, will you be happy? So if the government says, let Mukherjee goes, let him go, and let him go. Because no stigma should be there. If you allow them to write something in excuse, they will create something, write something because they want that you should be removed. I do not want in my personal life that any such picture should be recorded by a committee of patrons in their proceedings against any of the resolution professionals, because it will harm his future. He may lose one particular proceeding, but he will be going to another one. Removal, I am removed X. Why? It is not a stigma. But if they write something, and if it is reflected by the adjudicating authority in his order, then it will be easy. So you will have to think twice. Why?
Because if such unfettered powers are given,
I am saying, if that power is given to me as a plate owner, then I'll have to write something to the program. Will
if
you
I
write?
have not done anything wrong, why should I worry?
Then,
Otherwise, I am becoming a slave of this committee of creditors.
please understand, it is your choice.
Sir,
If-
but
Please, just-
One by one, please don't interrupt.
It is your choice. If you want that, let them give a reason.
sir,
Don't we think section 27(1) says that reasons have to be there?
No.
That's how my lord, I
If it's the
feel.
opinion of the committee of creditors,
That is a formation.
judicial professional required to be replaced.
Please, opinion and reasoning are two different things. My opinion is one thing. I may have a good opinion about you or a bad opinion about you. If I write it as a reasoning, am I clear? So, you want it in some judgment, then I'll be writing. If you welcome it, you empower me, I'll be writing, give a reason. And I know that you will be writing something which you have not done. You know, the committee of creditors, when bent upon to show you, they can write anything in reasoning. I have received a letter today that I have taken 50 lakhs of loan. This bribe. This is a letter, you come and see in my chamber. And I have asked him to file an affidavit and come before me. And I know there is no such person. Now, you called for. Do you like it? Do you want it should be recorded? It will be reflected in the judgment of the adjudicating authority or the judgment of the tribunal. If you like it, very good. Then one may say that in my case you write it. You will say that anybody who wants
But she absolute discretionary power to see.
sometime there's a voting. If the majority do not want, one man's recommendation you have come. One financial critter recommended and you have come. And 5 financial critters are saying you go. Look from this angle. You have been taken in merely because of one. I am telling you one thing. I am engaged as a lawyer and tomorrow they say you go. Should I say that give a reason for my going out? You are a professional. Please understand, a lawyer is a professional. Is it? Many clients are coming and taking the no objection from the lawyers and going. They are not satisfied. But that is the, we look from the angle. I was a lawyer. I was a professional. From professional side I have come to this side. I have a respect for the professional. And if you want, the professional should fight for a case. I think that will not be good. That means you are interested somewhere. The interest is not your profession, but somewhere else.
Sir, sir,
It's not a prestige issue.
we'll go to the next question.
No, sir. Many of them say you are not in the panel. We have made a panel. And we have dealt with 3 cases. Punjab National Bank.
If these where they have said you are in the panel, you are not in the panel, that we have passed.
Correct. That's the problem. That's
That
what
we
you
have
said,
passed.
panel will become
If they say you are in the panel or you are not in the panel, we have passed in those cases. That the ground is not a stigma against you, but a different reasoning. I am saying a simpliciter, a person is functioning, is asked to go. I don't require it. It's like an advocate who is arguing for 10 days and after the 11th day, the party says, I don't want from you. I'll be taking another lawyer. I'm comparing like that. If you are a professional, if you feel that I am an employee, then show us notice.
Right, Lord. We have understood. We have understood. Lord, there is another question which comes from the amendment rule. You will not refer the amendment. Section 4, Section 7, subsection 4 has been amended. Now to provide in the way timeline, if a reasoned order is to be passed as to why admission or rejection has not been done in Section 7.
Is there any order the Government of India Parliament received which is not a reasoned order? All Section 7 and 9 orders are a reasoned order, either admitting it or rejecting it. I have not seen any order which is not a reasoned order.
What they now say is that the adjudicating authority has not ascertained the existence of default and passed an order within 14 days. So then, my lord, they say that it shall record the reason. Although I remember my lord clarified this in JK Jupil's long back, 2 years back, my lord said this is guaranteed and not mandatory.
Please look into company law.
Please.
Company law 2013. In the company law 2013, there is a time prescribed to dispose of within 3 months. And they say if you do not dispose of, give a reasoning and send it to the chairperson or the chairperson. It's just reasoning. We give a reason. In absence of time, the case is adjourned, could not be heard, adjourned. That's the reason. We don't have time, and therefore we are adjourning. This is the reasoning. It's an art of writing is for lawyers, judges. Don't bother.
My lord, the parameters which are there for feasibility and viability. So what does my lord looks at when the plan comes?
Please, have they said to a resolution professional and look into the feasibility and viability. It is not your source. It is not your subject. Feasibility, viability is not your subject. Subject is you look into whether it is in accordance with the provisions of the subsection 2. Therefore, don't go on feasibility, viability.
Now in this amendment they have added in subsection 4.
That is committee of creditors, not you.
Right, Your Honor. Because I have to present the plan before them.
We let them decide if you see. If you look into the judgment of the creditors. Switzerland says the financial creditors, they give the loan, they know in what circumstances the loan are given, so they are the best person to find out the feasibility and viability of the corporate debtor. And subsection 4 says they will look into feasibility and viability of the plan. Please understand. They are in the committee because they know the feasibility and viability of the corporate debtor, and this subsection 4 says to look into the feasibility and viability of the plan. And then the Swiss Ribbon says NCLT, wherever has gone to the feasibility and viability of the resolution plan, not corporate debtor. And always if it is found to be, same treatment is not given to the operational creditor like the financial creditors, either set aside or substitute the plan. This is the feasibility and viability we can see of the plan. They can see the feasibility and viability of the corporate debtor and the plan. And you can't look into the feasibility and viability, that's why you don't bother.
Lord, with regard to section 12A, now what is happening is that there is a case in which the plan was approved by COC. The application was filed by RP before the adjudicating authority, and then section 12A application was moved for seeking the withdrawal of the admission when the plan has already been approved by COC.
Do the 12A deprive the committee of creditors from passing any order? Suppose you have approved a plan and it is more attractive. Which one you will choose? Which one you will place? Withdrawal or the plan? So let the committee of creditors decide. What we are saying, that all these questions are unrelated to the resolution professionals. What committee of creditors should do, what we should do, are not the subject matter of you. Plan given, 12A given, you place it. If they approve, you go before them. Am I clear? Your job will be clearing up to, and they say that you move before the adjudicator university, please move. If they approve 90% 12A, even thereafter, and say to move for withdrawal, who will move for withdrawal? You will move on behalf of the applicant. The applicant will ask for withdrawal. So applicant will have to agree, and then in that case you will move. Mark one thing, that approval of the plan, etc., committee of creditors have not been allowed to go to the adjudicating authority. Applicant has not been allowed to go to the adjudicating authority, only you, resolution professional. Am I clear to you? Only every person can go directly under 60 subsection 5. Otherwise not. Yes.
With regard to the provision for section 7 laws, if there is no written agreement, although I have read a judgment of your Lord,
Agreement is not required.
not required. Lord, in that case,
It says of any record as prescribed in the board, and board has prescribed in part 5, part 4 and part 5 of form 1. Mark it only one thing. It is not a litigation. It is not a suit. It is not a recovery proceeding. We have said, do you know why? Do you know why? Why you have said it is not a litigator? Why it is not a tool? Can you tell me? You are the corporate. He triggers against you. The moment he triggers, he can't recover from you. Corporate is safe, is not to pay a minimum amount. A third party, say me, is the applicant and I am paying to him. I am satisfying him. Recovery proceeding is from you. Suit will be always against you. Everything will be against you, but it is not against you. But I am satisfying and you, not you are satisfying. So it is not a suit. Therefore, the question of agreement, this, that, argument does not arise. All these legally judgment or bogus judgment of the advocate. The moment a detailed judgment is given this type of, we practically laugh. Because the Honorable Supreme Court has said in 4 paragraphs, paragraph 27, paragraph 28, paragraph 29, and paragraph 30 of the innovative. Now what they have said, section 7 only to be seen whether there is reject and default. What corporate can argue is there is no debt payable in law or in fact. Why in law? Like mother-in-law, father-in-law? Why debt is not payable in law? That means that there is a limitation, part where limited to not payable in law. In fact means somebody can show that I have already paid. There are other arguments which can be advanced, that's for lawyers. It is not a financial debtor. I am not the corporate debtor. Walking. So those are the arguments for the advance, not for the distribution professional.
One issue which I personally face, in fact, while checking this, with regard to the default, in case there is no written agreement, then how to see what is the agreement of...
Am I addressing the lawyers like you or the professionals?
No, it's a mixed audience, it's a academic session, so
Okay.
it's a mixed audience.
Okay.
In case of...
You understand. Any document, the Honorable Supreme Court says about section 9, that if invoice is raised or section 8(1) notice is given, a pre-existing dispute should be prior to the raising of the invoice. No, invoice is enough. I have raised an invoice. Enough. What more document is required of that? A document to show no agreement is required. I ask you to supply. You supply me. Amazon, you make an agreement. You give a call, supply. Many places you are giving online request to supply and they will raise the invoice. Medicines are coming. Many things are coming. Only many things are coming when you are making the payments for visit and agreement is there. So supplying goods to see in the market, online the supply is made and subsequently you are paying them. And why these people, because they are all retired people like us, they do not know this online transaction. So they say agreement is not there. So it is a question of agreement. Invoice has been raised, matter has been gone. So it has been supplied in the evidence. And there is no evidence to show that I have disputed prior to that quality is bad, or I have received less material only this much. So those are the factors that
Email request can be taken as
we are looking into. Email is an evidence. We are citing email as pre-existing dispute. Electronic notice we are giving, and why we will not be taking any record?
One very different question has come, that whether CIRP proceedings can be initiated against a stuck-off company.
I think that will be pending or we have delivered the judgment.
I have not come across. So, if it's already come up, then we lost.
Wait for 2 days.
And we not, if...
But before that, I'll be requesting you to look into one provision. Section 248, subsection 8 of the Companies Act.
I find
Also see
binding
subsection 7 of section 248, because that is mandatory, because by the passing an order under 242. Struck off is under 253, 252 and revival 252 and struck off is 248. What is there in the subsection 7?
subsection below 8 is
7. Anybody has Companies Act with you?
Can I read?
Yes.
The liability, if any, of every director, manager or other officer who was exercising any power of management and of every member of the company dissolved under subsection 5 shall continue and may be enforced as if the company had not been dissolved.
And what is subsection 8?
Nothing in this section shall affect the power of the tribunal